What student loan borrowers need to know after a federal court struck down Biden's forgiveness program. Student loan borrowers are now waiting indefinitely to see if they'll receive debt relief under President Joe Biden's student loan forgiveness program after a federal judge in Texas struck down the program Thursday, declaring it illegal. The Department of Justice immediately appealed to the Fifth U.S. Circuit Court of Appeals. But that case will have to play out before the Biden administration can cancel any federal student loan debt under the program. While the Biden administration has faced several legal challenges to the student loan forgiveness program since it was announced in August, the ruling on Thursday is the most significant setback thus far, prompting the Department of Education to stop accepting applications for debt relief. Under the rules of the program, eligible low- and middle-income borrowers can receive up to $10,000 of federal student loan forgiveness and up to $20,000 in cancellation if they also received a Pell Grant while enrolled in college. While it can be tough to follow all the various legal challenges, borrowers can subscribe for updates from the Department of Education and check the Federal Student Aid website for further information. If granted, and if a different appeals court ends its temporary stay on the program in a separate, pending case, then the administration would be allowed to cancel debt before a final ruling is made by the Fifth Circuit. For the 26 million borrowers who have already given the Department of Education the necessary information to be considered for debt relief, 16 million of whom have already been approved for relief, the department will hold on to their information so it can quickly process their relief once we prevail in court, said White House Press Secretary Karine Jean-Pierre in a statement Thursday. The Biden administration has argued that Congress granted the Secretary of Education the power to broadly discharge student loan debt in a 2003 law known as the HEROES Act, which was passed in the wake of the September 11 terrorist attacks. The government's lawyers argue that the law allows the Secretary to discharge debt in an event of a national emergency, including the COVID-19 pandemic. But the Texas federal judge found that the law does not provide the executive branch clear congressional authorization to create the student loan forgiveness program. One plaintiff did not qualify for the student loan forgiveness program because her loans are not held by the federal government, and the other plaintiff is only eligible for $10,000 in debt relief because he did not receive a Pell Grant. They argued that they could not voice their disagreement with the program's rules because the administration did not put it through a formal notice and comment rule-making process under the Administrative Procedure Act. The states have argued that the Biden administration does not have the legal authority to grant broad student loan forgiveness, as well as that the program would hurt them financially for a variety of reasons. A lower court had dismissed the case, ruling that the states did not have legal standing to sue. The states immediately appealed to the Eighth Circuit. One lawsuit, filed by a Wisconsin taxpayers group, was also dismissed by a trial-level federal judge, ruling that the group lacked standing to bring the challenge. The plaintiffs had argued that the loan forgiveness program, which is estimated to cost about $400 billion, would hurt taxpayers and the U.S. Treasury. Supreme Court Justice Amy Coney Barrett also rejected the taxpayers group's request for the Supreme Court to intervene. The Arizona complaint also argues that the forgiveness policy will hurt the Attorney General Office's ability to recruit employees. If Biden's program is allowed to move forward, individual borrowers who earned less than $125,000 in either 2020 or 2021 and married couples or heads of households who made less than $250,000 annually in those years could see up to $10,000 of their federal student loan debt forgiven. If a qualifying borrower also received a federal Pell Grant while enrolled in college, the individual is eligible for up to $20,000 of debt forgiveness. There are a variety of federal student loans and not all are eligible for relief. Federal direct loans, including subsidized loans, unsubsidized loans, Parent Plus loans and Graduate Plus loans, are eligible. But federal student loans that are guaranteed by the government but held by private lenders are not eligible unless the borrower applied to consolidate those loans into a direct loan before September 29.